Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are with John Yoo discussing his new book, co-authored with Julian Koo, Taming, Globalization, International Law, the U.S. Constitution, and the New World Order. John Yoo is a professor of law at the University of California at Berkeley and a visiting scholar at the American Enterprise Institute. He has written a number of books, including those that address foreign affairs, national security, and constitutional law. Those are Crisis in Command, A History of Executive Power from George Washington to George W. Bush, War by Other Means, and The Powers of War and Peace, and he co-edited a volume of essays on terrorism recently released, Confronting Terror, 9/11 and the Future of American National Security. He has also written a number of scholarly essays, law review pieces on these same issues and questions in a lot of leading publications. John was also a Deputy Assistant Attorney General in the Office of Legal Counsel for the U.S. Department of Justice, where he worked on national security and terrorism after the September 11th attacks, and he was also a clerk to Supreme Court Justice Clarence Thomas. John, welcome to Liberty Law Talk.
Oh, thank you very much, Richard. You left out the most important thing. I'm a big fan of the Liberty Fund. I have a lot of the books. I've been buying them since I was a student and have gone to several of the symposia, and I think this is a great initiative the Liberty Fund is undertaking here with the blog and the book reviews, and I hope you guys have the greatest success, despite having me on.
Thank you very much, and we're glad that you've been coming to our conferences. Let me start from the beginning. Your book is on the growing movement to escalate international law and bring it into prominence within the domestic political order of our country. And you're largely addressing a group of scholars and thinkers that we might refer to as the transnationalist or the internationalist, or those who would use various means to make it easier to incorporate international law into our own domestic law. I wanted to begin by reading a quote from one of the leading scholars of this movement from your book, Anne-Marie Slaughter, and get your comment on it. And leading up to her quote, perhaps I'll read some of your thoughts in this passage. In this vision, you say, international institutions and international law reverse the traditional understanding of sovereignty. Sovereignty originally meant that a nation-state was free from any other form of governance in its control of activity within its borders. But, according to the theories promulgated by academics and advocates, however, sovereignty is defined not by independence, but by a state's ability to fulfill international obligations. Now, here's what Anne-Marie Slaughter says, quote, "Sovereignty now is where the defining features of the international system are connection rather than separation, interaction rather than isolation, and institutions rather than free space. Sovereignty has autonomy, makes no sense," end quote. And then right after this, you cite another scholar, "Connection to the rest of the world and the political ability to be an actor within it is the new status of sovereignty." Talk about those quotes and situate them within the overall thrust or the ideological core of this international movement.
Yes, I think most people only see this come out in fits and starts, but there is, I think, a well-defined ideology behind it. So when people see claims that we need to, as in the war in Libya, wait on the United Nations Security Council before the United States can use force, or we have to try to get the Security Council to approve force in Iraq, or you see efforts with the Kyoto Accords to get the United States to bind itself to the quotas on the use of energy within the country, or to reduce greenhouse gas emissions in the future, or you see it in trade. So I think trade, you see the effects of the ideology, the cutting edges of it, popping up here and there. But so I think a lot of people see it, but they don't understand what's behind it, or they know there's something that makes them uncomfortable about it, but they haven't really thought it through. what's behind it all is this, I think, fundamental, really radical change in the way a good collection of scholars, government officials, international folks, the way they want to reconceptualize what national sovereignty is. And I think the quotes that you read, Richard, really state it very boldly and clearly. It used to be that sovereignty was essentially autonomy. In fact, the Liberty Fund has a number of books, really reprinted a number of excellent books from thinkers over the centuries about what sovereignty is. And sovereignty was the idea that no nation was bound to anything to which they didn't consent to, and that everything within a country's territory was within its own absolute jurisdiction. And this is an idea that comes from long ago, but was stated in American law by Chief Justice Marshall, one of the earliest Supreme Court cases, and I think has really been the idea that the United States has operated under for its history. Now we have this idea that we need to cooperate to handle the big problems of globalization, like pollution, like human rights problems, like war, like trade, and so on. And so what this ideological vision wants to do is to replace the idea of sovereignty equals autonomy for nations with something else, with this idea that there is something they sometimes call global governance, the idea that sovereignty has to be subjected to some higher power at the international level. And as one of the quotes you read said, this would be the idea that international institutions are really the institutions in charge above governments, and that autonomy no longer works. Instead, the institutions will guide, even perhaps dictate how nations are to cooperate to solve these great problems, rather than what the United States has always traditionally done, which is to do it nation to nation through treaties and writings and so on. I think it's a very radical change in the way we have thought about sovereignty in this country and in Western political thought for centuries.
Just putting to the side for the moment concerns about, say, the rule of law or political accountability, transparency, even the notion that politics, going back to Aristotle, is actually that's part of being a human person. This is something we do, is make decisions and give account for our rule and the ways we want to be ruled. So, and those are huge things to put to the side for the moment. But looking at Anne-Marie Slaughter's quote, she does have a point in terms of the accumulation of law, the interactive process, which you and your co-author lay out in the first chapter. There's the growth of globalization, and all of that encompasses, even from, say, a Hayekian evolutionary standpoint, thinking about the development of law. I mean, is it not the case that cooperation needs to happen across legal systems and should be facilitated and coordinated in the ways that some of these scholars are suggesting, that this would actually be beneficial for, say, free trade, human rights, maybe even, thinking of President Obama's advisor, Samantha Powers, forestalling, genocidal acts?
I think I'm with you halfway. It's the conclusions for what has to happen to get cooperation going and what that means for the American constitutional system, where I disagree with these scholars and this larger worldview. I do think that there are serious problems which affect not just the United States but the rest of the world, and we need to cooperate with other countries to solve them. I mean, some obvious examples would be pollution, drug trafficking, terrorism, things where we can't solve the problem by ourselves because the problem doesn't exist just within our borders anymore. You need to cooperate with other countries to solve some of these problems. Even just solving some kind of environmental issue between the United States and Canada or Mexico requires a cooperation of another country. So I quite agree that there are these problems and that you need some level of international cooperation. But to me, this is not something that requires a fundamental change, or we need not rush into some fundamental change, though, about how our Constitution works. How our political system works.
I think there's a nice lead-in really to one of the core pieces of your argument, in that you set forth the way we've thought about sovereignty, say, for the last 400 years as a Westphalian system, the Westphalian state system, and then you have this newer paradigm which we've been discussing. But then your argument doesn't seek to defend the Westphalian system as it's been understood. you argue for something like the principle of popular sovereignty as expressed in the United States Constitution and the allocation of power within the Constitution. That's how you're framing this debate. And so, in many respects, you're not foreclosing things, but you're saying the change that will happen, that in some cases must happen, has to do so through the structures of the Constitution, and of course those two main ideas, federalism and the separation of powers. Let me ask you, what are the core political values you think are at stake in this debate?
Yeah, Richard, first, you're quite right. I think we're not against cooperation at the international level. We just think it has to be channeled and managed by the Constitution, as everything our government does and everything our political system does. And here, I think the framers were quite foresighted. They didn't think the United States would be acting autonomously by itself all the time. Instead, they did create certain provisions so that the United States could cooperate internationally, could address these problems, but hardwired into it were the same principles that underlie the other areas of the Constitution. As you said, the separation of powers and federalism. With separation of powers, there's two ideas that have always been in tension that dictate this. One is that you have three branches of government. This is a Montesquieuian idea. Three branches of government. They perform the executive, legislative, and judicial functions, and we try not to let the branches interfere with each other in the performance of those jobs, except when the Constitution makes specific exceptions. For example, the President and the Senate sharing the treaty power. But just because the President and Senate share the treaty power, for example, this is a very important mechanism for us, that doesn't mean they can start passing laws in the country willy-nilly. The Congress still is the body that exercises the legislative power for the United States. So the President and Senate can make a treaty, make an international agreement, but still requires Congress to implement it, just the same way Congress passes all legislation at the national level. The other great principle, as you said, is federalism, that there is a certain balance between the national and the state governments. The states are not subdivisions of the national government. Sometimes I fear politicians in Washington think of states this way, as states are thought of in Europe, for example. And in this system, there are certain subjects which are reserved for states and certain subjects referred for the national government. As you said, you raised Hayek, and I think Hayek actually still has a lot of applicability here, in that Hayek favored decentralized government because, as you know, the difficulties of any single decision maker or one government to collect all the information necessary to make decisions when the market does it much more effectively. You can think of federalism as creating a market of government, and where governments compete at the state level for the most effective and efficient policies and the policies people want. And we don't think, our fundamental argument is that just because we're engaged in international cooperation, just because we're engaged in a world of globalization, we don't deny that. But that doesn't fundamentally change these two basic hardwired principles that our framers put into the Constitution, separation of powers and federalism. Instead, what we argue is that those two principles have to operate in the same way, even though the subject has changed. Just so you use the same process domestically to pass a criminal law, that's the same process you have to use to implement a treaty.
Let me ask you this question, and if you want to address this. Something that I found interesting in your book, and I want to make sure I understood your point correctly, was you refer back to the New Deal and kind of the revolution in federal power that the New Deal launches. And of course, almost some of us would argue obliteration of the enumerated powers doctrine, or at least it's emptying out. Are you suggesting that there needs to be some sort, or were you suggesting that there needs to be some sort of evolution process change with regards to these customary international law or treaties or these other major international agreements that are staring at us, that somehow we need to have the ability to constitutionally balance the way the New Deal worked a revolution within the existing constitutional law, or did I misunderstand you? Because it seemed to conflict with kind of your overall argument the way I thought of it.
Yes, actually, to me, first of all, it's a great question, and to me, I guess it depends what you think of the New Deal, and I think you and I share the same perspective on the New Deal. So for me, the New Deal is a warning, and let me explain it. So with the New Deal, constitutional law didn't take account of the nationalization of the economy. And so one way you could understand the New Deal, we all study how FDR politically browbeat the Supreme Court into changing what I thought wasn't such bad doctrine, actually, about the Commerce Clause and individual economic liberty. But that was because that was the political, point of conflict. But the bigger thing that happened behind that was that people hadn't thought through how should the Constitution regulate nationalization of the economy. The court was trying to, but then the great crisis of the Great Depression caused the national government, as you said, to try to explode these two hardwired principles, federalism and the separation of powers. With the issue of federalism, we saw Wickard versus Filburn, which we're going to be talking about with the Obamacare challenge before the Supreme Court, where basically anything anybody does is somehow connected to the national economy and can be regulated as interstate commerce. And then, to my mind, equally damaging was the creation of the independent administrative state, the delegation of huge amounts of power from Congress to the executive branch, the lack of checks on how the executive branch uses this legislative power. So if you think about globalization, to me, is causing the same kind of pressures. And what I wouldn't want to see is us to do something like we did in the New Deal, where there's some kind of huge confrontation, and the end result is we just place no limits on how we deal with foreign affairs and international relations, much in the same way these internationalists are pushing for. So to give you an example, in the treaty power context, there is some discussion in Supreme Court cases that the treaty power is not subject to the limits of federalism. I think that was a mistaken decision. It's very obscure. It involves birds flying across the U.S.-Canadian border long ago. No one knows whether the court would ever seriously follow this doctrine again. This is, you would not be surprised, is the favorite doctrine of internationalists, because through the treaty power, you can do all kinds of things like pass a treaty which has been assigned by other countries on the rights of children against their parents, or a treaty that regulates small arms and guns in ways that federal government couldn't, and so on. So my worry is that if the New Deal story plays itself out again now, because we don't think about globalization, if we're not thinking about how to make sure our Constitution manages the problem, we'll have some kind of crisis. There'll be a confrontation between the courts and some temporary elected majority in Congress, and what we'll see is the stripping of the last few limits that the Constitution puts on our government. That's what deeply worries me about the period we're about to head into. You could say, in a way, we're starting to see it now with the Obama administration.
Let me ask you this. I mean, as contemporary and as new as these ideas and issues feel, you also reference, and I was delighted to see it, what was an enormous conflict in the first Congress over the Jay's Treaty. If I'm remembering correctly, it was the first Congress. And this really gets into another line of argumentation in your book between ratifying a treaty with 2/3 of the Senate and its actual implementation. And that's what was going on in the Jay's Treaty. Was Congress insisted that it wasn't actually applicable in domestic law until they had implemented it and appropriated funds for its implementation. And you talk about this in great detail. This, of course, relates now to what I think are the international organizations, the treaties. You mentioned the children's rights movement, et cetera. But thinking, and you argue that unless the treaty is self-executing, and I wonder how many treaties truly are or are ratified if they are self-executing. You point the principle should be non-self-execution, should be assumed, therefore giving power in the first house, the Congress, which is the most radically democratic. So talk about that for a minute, and talk about actually, if you would, mention kind of sketch out the Jay's Treaty conflict and how that contributes to this debate.
Actually, even more concrete than the Jay Treaty, the Children's Rights Convention, is the death penalty in the United States. We passed that over, but the one area you do see this happening is with the efforts of the anti-death penalty advocacy bar to use international treaties to try to stop the death penalty in the United States. And many people may not realize this, but they've actually had at least three or four cases at the Supreme Court trying to get the Supreme Court to order the halting of the death penalty with regard to non-U.S. citizens who are on the United States territory, kill somebody first-degree murder are sentenced to capital punishment. And so, under our federal Constitution, that's up to each state. Federal government doesn't have a power to prohibit the death penalty in the Constitution. These internationalists plus the death penalty bar have been going to court systematically trying to use treaties to block the death penalty and have succeeded to get as far as the Supreme Court several times now. It's really incredible. But that is, in a way, a repeat of the Jay Treaty, because with the Jay Treaty, to settle the remaining issues from the Revolution, actually, including the seizure of British property, and then the British hadn't left the forts that they had promised to hand over at the end of the war, and there were a number of trade disputes. The Jay Treaty created a number of very interesting, first of their kind approaches. For example, the Jay Treaty created an international commission, the first one of its kind, that would hear the claims after the Revolutionary War and would have a certain amount of money to pay out the claims. The Jay Treaty required that the creditors and debtors would have their rights unchanged from before the Revolution, that the Revolution couldn't wipe out all the pre-existing economic relations between Great Britain and the United States, as some state legislatures were hoping, because a lot of them had wiped out the debts of people that were owed to the British. But, so in the Jay Treaty itself, some in the Washington administration, including Alexander Hamilton, have wanted the treaty to, as you said, become self-executing. Just because the President and Senate made this deal with Great Britain, that the Congress would automatically have to fund it, that all these property rights would have to be restored automatically. And the important principle from the Jay Treaty that was fought about in that Congress, in the great debates, it was again just like things like the Neutrality Proclamation and the setting up of the first bank, and so on. The great debate. Jefferson, Madison, Hamilton all made their appearances in print or on the floor of Congress to argue this out. And Madison this time won, and the principle that he won on was that these treaties would not be able to take direct effect in the United States without Congress's permission as a whole, that Congress pays the bills, Congress passes the criminal laws, Congress has the power of legislation, and just because it's a treaty or just because there's some other foreign policy or international law involved, for Madison it was important that Congress still retain that fundamental legislative power. And I think today, fast forward 200 years, I think that's still the principle that the Supreme Court is trying to defend now. In these death penalty cases, the court has said, we are not going to consider that these treaties force the United States to change the way it considers the death penalty unless Congress is going to pass a law. And then it reserves the question, does Congress even have power to do that? But the court said just the President and Senate cannot sign away American sovereignty in terms of what happens inside the United States with a domestic issue like the death penalty. And so the court has stopped all of those efforts so far. You wish they were 9-0 cases. They're not. That gives you a sign of this kind of pressure that's being put on our domestic system, is that there are several justices who would be willing, justices of the Supreme Court and lower federal court judges who would be willing to halt the death penalty because it violates, in their mind, some kind of treaty obligation or an order from the World Court.
Speaking of, thinking of course, the appeal of this, for some would be that you're defending individual liberty against kind of as we say, more populist American electorate that really is fairly unique within the Western world. It seems to me, and you're appealing to these treaties, or you're appealing to other bodies of law to run around that. But of course, as you talk about, and you reference James Madison, and I found it ironic to think that the treaty power is so powerful that if you assume self-execution as the norm rather than non-self-execution, even the limits that Madison said were the true Bill of Rights to Congress in Section 9, even those could be stripped away. And so actually what you lead into is a runaway government or a government that really citizens themselves can't count on reflecting their wishes. Even constitutional limits are gone. So the question, how do internationalists deal with these sorts of questions? Do they address them directly, or is going back to our first kind of discussion, is the kind of progressive hope in the future in science and dialogue, et cetera, so powerful that these are kind of dismissed or not talked about?
Well, I think for a long time the internationalists just didn't take the Constitution seriously. That if you were to read what was written until really the last 10 years or so, people would commonly say, well, federalism doesn't apply to foreign affairs, or separation of powers does not apply in the same way and is much looser when it comes. And if you think about it, again, this is just like a rerun of the New Deal. These were the same arguments people made to press for independent agencies and to press for lack of federalism limits on the Commerce Clause power. They just were not taken that seriously because people were more focused on promoting this view of a narrower kind of national sovereignty. I think, though, what's happened in the last, a really interesting question that you asked is sort of, I think, what's been happening, though, in the last few years is that with the restoration of interest in the Constitution and the restoration of interest in limited government, which you see, it's not limited to one political party. You see opposition to these new initiatives of the federal government, and then it's just, I think those initiatives have just been accelerated the last 3 years with the real scope of the power of the national government vis-a-vis the states and vis-a-vis individual liberty when it comes to the economy. I think that has restored general interest, not just amongst scholars, but amongst regular people who are not specialists in law, in restoring the original Constitution. The thing that's impressed me has just been this real resurgence and interest in the framing, in the framers, and what the original Constitution means and what the text of the Constitution requires. And I think that's really, I hope this book is the first of others that will sort of cause this movement amongst the transnational internationalists to pause, to think about it, and to also get a dialogue going between people who are just focused on international affairs and don't think much of sovereignty, and people who understand that the Constitution is the way our government, the American people regulate our sovereignty and the nation's autonomy. When it comes to the other issue you raised, this issue about individual economic liberty, one just side point I wanted to make was I really think that a lot of the scholars and policymakers who favor these sort of transnationalist outcomes, that they take as their model the European Union. I think they see a lot of what happened in Europe as a success, and they tend to overlook the serious defects of the European Union, which I think our Constitution was built to prevent, which is distance between the government and the people, lack of accountability. Even in Europe, they call it the democracy deficit. Now, when you hear people, scholars and policymakers from Europe talk about government, they almost see democracy deficit as a good thing. They think that people are, always trying to force them to do things that they don't think is in their best interest. And I think in the United States we have a very different opinion on that. And I think our Constitution is designed to prevent that kind of democracy deficit from happening, and really to prevent the kind of system that has arisen in Europe from arising here in the United States.
It does seem, and something that I thought of, Charles Murray has raised in several pieces the idea that we are going to learn from Europe in terms of the implosion of their welfare state, that this is going to have a kind of a teaching opportunity for America to think about our own welfare state, and assuming, say, we're 5 years or 10 years from the situation that many European countries are in. But it also seems, in reading your book, there's a teaching opportunity for the European Union and the European Court of Justice, and the ability to reach into the domestic law of Britain or other nations and really determine things that are seem best left to local politics, and which are not. If you read about all of these cases, particular parents in Scotland running afoul of European Union legislation over, say, how they punish their children or things like this, which just strike you as almost kind of a despotism. To think that decisions could be that removed from people. I wanted to ask you the question, because it seems, so the treaties, and we have, we all think about the press, the gathering for international organizations and their prescriptions and the things they, very sexy questions, issues they address. But it seems maybe what's even more dangerous is customary international law, which you spend a great deal of time on talking about in Taming Globalization. But also in the context of globalization itself, customary international law and the sources that make it continue to grow. and can be appealed to in a proliferating variety of ways to actually force your preference as customary international law, it seems. But to talk about this for a minute, and the question, how is the process one would go about? I mean, are there recognized canons for determining what customary international law is? I mean, it seems to me the most radical claim is because something is passed on the floor of the UN General Assembly, somehow it becomes customary international law. But, there obviously is a substance to this that our courts have recognized throughout history, but there's also a new reality we should think about.
Yes, I mean, one way to think about it or to view it is that this effort to use these foreign legal sources, customary international law, foreign law, the Supreme Court, some justices have shown this receptivity or sympathy for this, is fundamentally, in my mind, anti-democratic. Right? If you look at how it works, you're taking some kind of norm, some kind of principle from outside our constitutional system and trying to insert it into our system. And so I often think when you look at who's on the side of these cases, the people who are often trying to use customary international law are doing it in the United States because they are not happy with the way the democratic process worked out here. Again, the death penalty is the best, most sort of recent example. It's being used by people who don't like the fact that some states have chosen through their democratic process to have a death penalty, and so they're trying to import from outside our system some kind of value or some kind of principle that the American people never approved, and they're trying to do it through the least democratic branch, which is the courts. And I think they're really trying to change the courts away from their fundamental job, it seems to me, which is to defend the individual liberty of Americans within our constitutional system from times when the government goes beyond its limits, to this kind of body that's trying to mediate and trying to incorporate the United States into some kind of broader global governance. And the reason for that is because as you really hit on the nub. There's a change in what international law has become, or at least what some people think it's become. It used to be that customary international law represented settled practice by states over many, many years. And so if there ever was a time when customary international law, and customary international law, as you said, is law that is unwritten, non-treaty law. A good example would be the principle for centuries that you do not try to shoot at civilians during wartime. For many, many hundreds of years, that was not written. Everybody just followed it and knew it. There was a principle of war going back to Rome, to the ancient world. The reason that was not a democratic problem was because the United States consented to it, too. The United States could not be held bound to some kind of unwritten rule unless we consented to it by our practice and our own declarations. Now, as you said, there's this new kind of international law that comes about through all kinds of diverse sources, often, as you said, UN General Assembly declarations, even though the UN General Assembly, even under the UN Charter, has no real legal authority to issue any kind of legislation. It's not really a functioning world government. Books written by law professors can sometimes be used as evidence of some kind of customary international law. Decisions, as you said, of the European Union courts, even though the European Union courts are only representative of Europe, or the decisions of foreign countries' courts, even though those decisions obviously don't bind us. This is kind of a new kind of international law that creates these kinds of principles much faster, and sometimes without even the consent of the countries that's used against. And so that's very disturbing to me, because if that's actually allowed to happen, then you've created a way to sort of make up a new law on the cheap and on the fast, where the United States never really gets to consider it and make a decision about whether it wants to follow it, and then trying to force that through our court system as a rule of American law, without having to go through Congress, the regular sources of lawmaking, and go through the House and the Senate and signed by the President.
Right, and you mentioned as well that there's the appeal surprise to the federal courts as the kind of sole arbiter of determining what is customary international law, what's going to be incorporated into our law.
Yeah, in that respect, it is like the New Deal again, and sort of what happened in the 60s and 70s, where progressive scholars used to openly talk about how they didn't want the courts just to decide cases between private parties or defend the rights of individuals. They wanted the courts to intervene in society and change the way things worked. Like they wanted all the schools to be run by the courts and prisons, institutions. They wanted, and if you go look at the scholarship behind this, they would say, courts are there to announce public norms and rules of morality for the American people. It wasn't just about their constitutional role. And what's going on now reminds me, it harkens back to that earlier view of the Warren Court, and I think the worst examples of judicial activism.
It is interesting as well. I mean, and this could just be my strangeness, but think of a core of groups, a core of professors who intellectually would be very much opposed, I think, to Anglo common law and to the kind of the epistemology of Anglo common law, which was at one level empirical, but also the notion was that you kind of discovered through habits, through customs, how people interacted and what would be, say, efficient outcomes and outcomes that, preserved, a voluntarism within the people. And this seems to me that's kind of what customary law, international customary law is about. But yet now it's kind of like you're gonna transfer it over to something that's being generated and produced, exactly. and then hammered down to achieve XYZ result. Your solution though is interesting. I mean, it struck me by surprise. Not your solution, but your framework, again, this popular sovereignty framework with regard to customary international law, is that the states have a tremendous role in determining this, and actually it's the law of states really is how customary international law should be implemented. But this would be subject, of course, to override by the president. When he chose, then he would be able to, to thwart any of that's going on. But so the immediate comeback to you as well, does international business break down in America at a certain level because there's now 20 different jurisdictions understanding customary international law? I don't know. I'm just thinking, and also, of course, the ideological claim. Yeah.
Well, first, I think you're quite right. You're quite right about what customary international law used to be like, and I think actually ties in with the vision of the states, was that customary international law was in many ways similar to the common law and has this kind of Hayekian mechanism behind it, right? That you have a decentralized system, lots of actors. You see the best outcomes come out when all those people are operating and able to, right, the nations here rather than individuals are able to shape their interactions following their own interests. But because of that, just like the invisible hand in the market, you get certain principles that recur, right? That's the vision you had. You were just sketching the common law. And I think that does apply to customary international law. But you're right, the new customary international law tries to short-circuit that process. Just the way legislation, in a way, short-circuits the common law. And a legislature can intervene into the common law and pass some rule without due consideration, and it can ignore all that large amounts of information and best outcomes. The reason I think states actually make some sense, though, is because, first of all, I think states are much better than having the federal courts do it. I mean, the states can choose to do it through the legislative process just the way, or through the common law, just the way they set all the rules of torts and contracts and so on, too. And so to me, I guess, I don't worry so much about, I mean, there is this criticism I think is quite a valid one that you raised about, well, what happens if you have too much diversity in the country and it starts to undermine commercial activity where for centuries we've always understood that you want to have a national national unified market in the United States with certain common principles. But you think about it, in a lot of commercial activity, we do allow the states to regulate with different priorities in mind. So the basic rules of contract are different in every state. Now, they have over time moved towards some very common principles. But, the contract law is a creature of state law. Corporate law still is. The law of accident. So we still do allow the states to have that fundamental responsibility to regulate a lot of things that affect our commerce and business and the national market. But over time, we've seen it evolve together to where the states basically agree on a lot of common principles. I think I would hope that would happen with customary international law too. That when it comes to, say, responsibility of corporations for accidents overseas or things like this, or the kinds of contracts that international business should be able to enforce in a state. Again, I think that each state is better than having the courts do it. There is the chance that you could have 50 different rules, but just like with the common law, we've placed our trust in the common law, and I think it's worked. We've seen this evolution towards basic principles, and I would hope and expect that would happen with law affecting international affairs too.
It seems to me it's also a way. Your argument is, and we can maybe get to this towards the end. I was just thinking about also the integrity of the federal courts and the legitimacy of the federal courts. If they assume the role many of them would want with regard to incorporating customary international law, it seems they've put themselves in a position that may not be very favorable. Regarding most people in this country, or certainly a majority of voters, and find themselves frustrated, as opposed to a process where the states and the president are really kind of bargaining, and so there's this political component, and maybe the federal has a more limited role of just declaring things. I just want to bring us to a close. You also make another argument that isn't purely constitutional, but is kind of an institutional competency argument with regard to these questions, or whether it's customary international law or international treaties dealing with authority that's been delegated to international organizations to enforce various treaties and agreements. And that is, what does each branch bring to the table in terms of its core strengths and weaknesses? And this is something that seems to be glossed over, I think probably glossed over maybe because of an ideological goal, or maybe a preference that even if the courts are weak in doing something, we should still give them that authority because they're able to pronounce so unilaterally and with such specificity without a bargaining process. But talk about those kind of cluster of arguments you make.
Yes, thanks. I'm glad you brought that dimension of the book out because we make arguments based on what the framers thought when they were writing the Constitution, the basic framework of government. But we also want to address people who are not originalists, people who think that, the Justice Breyers of the day, people who think we ought to take consequences directly into account and not worry so much about the original understanding of the constitutional text by the people who ratified it. And in that respect, what we try to show is that legislatures, executive branches, and courts are good at some things and bad at other things, and that this excessive reliance on the courts, as you point out, which comes from other areas too, has happened in other areas too, has two faults. One, it does. I agree with you. It does potentially undermine the legitimacy of the federal courts, as I'm sure you've discussed and talked about in other fora. The institution of judicial review has serious problems with it. It's counter-majoritarian. It acts against democracy. It's not clearly written in the Constitution. You have to infer its presence. So the courts should be careful when they try to impose things contrary to the wishes of the people, and they should they should do it where the Constitution is clear. But when the Constitution is not clear, they should be wary, I think, of creating new rights and trying to override the political process that's set out in the Constitution. Think how much worse that problem is when the courts start to say, well, we're not doing this because we think the Equal Protection Clause or the Due Process Clause, some part of the Constitution requires it. We're doing it because we think some practice in Europe or some unwritten, unratified agreement requires us to do that. When they try to pull some source of authority from completely outside the United States system, I think that seriously undermines the political legitimacy of the courts double-fold compared to the normal problems you have with judicial review. And the second point, I quite agree, is that if you were designing a constitution for the first time, and so this is just not a point about the framers, though I think the framers did have were very gifted and inspired people. But if you were thinking about the Constitution now, why would you want the courts to be the institution of our government that was on the front lines thinking about how to manage foreign affairs, how to manage globalization? The federal courts have certain advantages, which is, I think, their best one is defending minority rights from the majority when there's a clearly written right and when it comes in the form of a case, when the government is after an individual and the individual has a right they can raise as a shield. I think that's a prototypical kind of case. That's the kind of case in Marbury v. Madison makes clear is the job of the federal courts. Congress and the executive branch are much better at figuring out broad social problems that are not limited to one case, mobilizing society's resources, establishing a general rule of law, specific policy, and executing it, which is what you really need in foreign affairs, because foreign affairs are so difficult and unpredictable and require so much. The worst thing you could have is a court unfortunately, this happens in domestic affairs, but I think the consequences are just much worse in international affairs. A court only sees a sliver of a problem because it comes to it in a case. And you don't want the courts to set the nationwide policy just because of what it sees in this one, could be very idiosyncratic case. That's why I think it was Holmes who said, bad facts, hard facts make bad law. One reason that's true is because that case you see before you might not be the case in 95% of the instances, and you shouldn't set the rule for the country based on one instance. That's what courts do, and that's, I think, very dangerous when it comes to dealing with globalization of foreign affairs.
Which also defaults back to something we've lost, which is the way common lawyers or common law judges understood precedent. It was evidence of the law, but not necessarily the law itself. That, of course, seems to be eroded. I wanted to end. You close with something that I think when most people think of these cases immediately comes up, which is the court's reference in some important cases within the last 10 years to foreign sources of law, not necessarily compelling their judgment in these cases, but seeming to provide support. Perhaps one of the more famous ones was the Lawrence case in 2003 dealing with the Texas sodomy law and references that I believe it was Justice Kennedy made in that case. It seems to me this is interesting. Scalia has pointed this out. How would one even begin that survey, that international survey? Who would you choose from? And when you're citing these sorts of precedents, maybe to justify something like an equal protection argument, but also the case. It seems to me that the type of enlightened morality that would find international justification for it is really kind of a minority view within the overall, in the world itself. You're not appealing to the Ugandan law reports or to the Saudi Arabia High Court or something like that. You're looking to say Belgium or I don't know. But talk about that those sorts of issues.
Yeah, there's two problems I think with foreign law. One is just how do you do it, even if you believed in it, which you're pointing, and then the other one is just why is this even a legitimate source in our constitutional system of authority? So as to the first question, which I think, as you're quite right, I think Scalia has spent most of his dissents on this issue, more on the how would you implement this problem, because the court has, in some majority opinions, as you said, in some recent cases, cited foreign law and made a nod to it. And the problem there is sometimes one judge has said about looking at congressional debates or legislative history to interpret a statute. It's not rigorous because it's just like looking out on a crowd and picking out your friends. So people will, in doing this, pick the issues where they find international law favors them, and they will only cite foreign countries that do what they like. So Scalia made this excellent point, which is if you really want to follow foreign law and foreign practices when it comes to how old you have to be subject to the death penalty. That was the question. What's a minor versus someone who's an adult? Then why don't we use foreign practice when we come to the right to abortion or the exclusionary rule for searches without warrants, where the American practice is an extreme minority compared to the rest of the world? The court just isn't going to be consistent. It's just driving towards foreign law and international law when it suits it, but they're not willing to live by it in a principled way. But I think that's too easy, because I think there's an even more difficult problem behind foreign law, which is that foreign law is law that's created, and it may exist in some other country, may exist some international body, but they're not created within the constitutional system of the United States. The Constitution just does not recognize foreign law. Every time it mentions any kind of law from outside the United States, the law of nations, it's called in the text of the Constitution, it doesn't exist unless Congress brings it in by statute. Other than that, the only sources of law are the Constitution, federal law, state law. And so the thing that really I think is of problematic, is really I think illegitimate, is bringing in sources from outside that closed system, trying to claim sources of authority from outside that system, because that undermines the constitutional system, because then there are decisions being made, there are principles being followed, which were never subject to public scrutiny in the United States, which were never passed by the House and the Senate, were never signed by the President, were never adopted through the state mechanisms. And you have Americans who have to live by a certain policy that no political system in the United States ever approved or put a stamp of approval on. And that, I think, is fundamentally unconstitutional and does cut against the idea of sovereignty, both in the old-fashioned autonomous nation sense or the kind of popular sovereignty that's embedded in the Constitution.
There's just, this has been kind of a thread throughout your book, I think, is there's just a crucial rule of law deficit. Beyond, just thinking we see a democracy deficit, but just the idea that law itself is going to be something you can predict, of, and is made or in some sense associated with a group of people politically constituted and connected. It seems to me that's just inherently thrown out the window under this conception of law, and it's you do have to wonder. Is the rule of law, if we can define it and articulate it, and I think we can. Is that even a core value for this group? It seems that it's really not.
Well, think about it. These are look what's happened in Europe. Right? It's in many ways, again, they admire Europe. They admire European government systems. And in Europe, if you look at what they've been doing the last 60 years, and look at the outcomes now with the collapsing euro and the problems in trying to have a unified budget and so on. But in Europe, that's exactly what happened. There is this huge democracy deficit. The people who've led European integration want that. They view sovereignty of the old-fashioned kind or popular sovereignty of the American kind as obsolete. They don't trust the people to make the best decisions for them. They don't trust the system you and I were just talking about, the system where millions of people, through their own private interactions, set the rules. They think that it's a very technocratic vision of the world. They think that experts can figure out the best rules for the people and should have the governmental mechanisms necessary to impose them because they don't think the people act in their own best interests. And I think that's, we've seen what's happened in Europe in that regard now, and I think that kind of vision is behind the idea of internationalism being able to change the way the American Constitution works, to get the U.S. more embedded into these international regimes and international institutions.
John, I think that's a perfect way to end our discussion. We've been talking with John Yoo about the new book he has authored with Julian Koo, Taming Globalization, International Law, the U.S. Constitution, and the New World Order. John, thank you for talking with us today.
Oh, thanks for having me. It's been great.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.